You can introduce yourselves briefly, to the teams and vice versa. And then I'll just say welcome to the 2020 All Africa Final, featuring teams Sepulveda against Team Maudsley. And there we go. So. See if it started. So, I'd like to welcome you all to the final of the 2020 FDI Moot All Africa Regional, featuring Team Sepulveda against Team Maudsley, with 3 esteemed arbitrators, Ms. Alexandra Samsonova, Mr. Rajesh Sharma, and Mr. Nikita Kondrashov. With that, I will turn it over to the presiding arbitrator to make introductions with the teams and to commence the proceedings.
Thank you, Christian. Hello, everyone. So we welcome everyone here in this arbitration of Goliath National Bank JSC versus the Republic of Laos, pursuant to the UNCITRAL arbitration rules. And first, I would like to invite my esteemed co-arbitrators to introduce themselves briefly.
Okay. Good evening, good morning, good afternoon, wherever you are in the world. I'm in Melbourne time. It's already 10:20 here, so it's a very in the evening. So good evening from me. I'm Dr. Rajesh Sharma, and I teach here at RMIT University in Legal and Dispute Studies program. And my specialty is in international trade, investment, and dispute resolution. Thank you.
Hello, everyone. My name is Nikita Kondrashov. I'm a Russian qualified attorney, and I also specialize in international arbitration, international commercial arbitration, and public international law. Thank you.
As already introduced, I'm Alexandra Samsonova. I'm based in Moscow, Russia, and I'm an associate at Latham & Watkins Moscow office. I'm pleased to hear the teams today in these arguments. And so have the teams agreed on the time allocation and the order of the pleadings?
Yes, we have, Madam President. I will walk you through that now. So the respondent will begin by addressing the procedural issues in 19 minutes. Then the claimant will follow with its version of procedural issues in 19 minutes. There will then be a rebuttal by the respondent and as a rebuttal by the claimant, with both taking 1 minute. And the claimant will immediately follow that with the merits of the dispute in 19 minutes, with the respondent following with its version of the merits in 19 minutes. Finally, this will be followed by a rebuttal by the claimant and as a rebuttal by the respondent, with both taking 1 minute.
Thank you. That is noted by the tribunal. Since we're all present here and agreed on the time and order of the proceedings, we now invite the respondent to start the pleadings.
Madam Arbitrator, may I intervene for a brief second? Would it be helpful if all the speakers would introduce them beforehand so we can take also notes as arbitrators?
Yes, I think we can do that, although we have the names, I think, written on the screen for each speaker.
Yeah, unfortunately, since I'm using my phone, I'm a bit at a disadvantage at the moment.
Yeah, I think it will be helpful then for you to also introduce and let everyone hear your names for the record.
All right. My name is David Omondi. I am appearing on behalf of the Republic of Laos and representing Team Maudsley.
Hi, my name is Mdathir Timami, and I will also be representing the Republic of Laos in the proceedings today. And I represent Maudsley.
Okay.
Hello, my name is Otitola Olufolajimi, and I'll be representing Team Sepoveda, representing Goliath National Bank in today's proceedings.
Thank you. So then the respondent, you have the floor. You can start whenever you are ready.
Thank you. Madam President, members of the tribunal, good afternoon from this part of the world. We cannot all be together physically, but we are fortunate to be able to come before you on this platform in what can be said to be our new normal. My name is David Omondi, and I appear on behalf of the respondent, the Republic of Laos. Unfortunately, not next to me, but still with us is my co-counsel, Ndathiri Timami. Also present is another member of our team, Yvonne Nyangi. However, she will not be addressing this tribunal today. With your permission, I would like to take the next 19 minutes to address the procedural issues, while my co-counsel will take 19 minutes to address the merits of this dispute, leaving 2 minutes for rebuttals and rebuttals. I will argue first that Mr. Mason should be replaced as an arbitrator in these proceedings, and second, that this tribunal has no jurisdiction over the present proceedings. Members of the tribunal, the dispute before us has arisen out of our legally acceptable attempt to protect the environment of Laos for the purpose of posterity. We're here today to show that the claimant cannot challenge the measures we took, as it does not meet the criteria required for it to be protected under the ASNEC Energy Investment Treaty. Our first submission is that Mr. Mason should be replaced as an arbitrator in these proceedings, and we argue that this is so because Mr. Mason is partial. I begin by directing this tribunal to paragraphs 1 and 2 of the respondent's challenge on page 45 of the record, where the reasons for bringing this challenge are stated. We believe that his appointment and involvement in the Hua Plants dispute and his failure to disclose it, taken together with his comment on social media following the award in that dispute, are all circumstances which would lead to justifiable doubts over his impartiality. In that respect, and based on the governing law of this dispute, which is the Ancestral Arbitration Rules of 2010, the respondent will argue that Mr. Mason is partial for 2 reasons. A, according to the test set out in the non-binding IBA guidelines, his appointment in the Hua Plants warranted disclosure. And B, even if this failure to disclose is not enough to warrant his removal, when taken together with Mr. Mason's comments, it is. With regards to our first argument, the applicable binding standard of justifiable doubts as set out under Article 12.1 of the Ancestral Arbitration Rules needs to be established for a challenge to be successful. In Gayo versus Canada, a NAFTA dispute in 2009, it was stated that, and I quote from paragraph 19, under the Ancestral Arbitration Rules, doubts are justifiable if they give rise to an apprehension of bias that is reasonable to an objective observer. Ultimately, the test here is whether the reasonable and objective third party is of the opinion that the circumstance in question creates a reasonable perception of a lack of impartiality or independence. We argue that Mr. Mason needed to disclose his appointment in that case, as a reasonable third party would have justifiable doubts due to the similarity of factual and legal issues in that dispute and the present dispute. This can be seen on paragraph 16 on page 70 of the record, specifically from line 1915 to line 1919. As per Article 11 of the Ancestral Arbitration Rules, an arbitrator should disclose any circumstances likely to give rise to justifiable doubts over the impartiality or independence. We contend that an arbitrator may not rely on other parties' counsel to discharge this duty, and this is a position that found favor in the Tidewater versus Venezuela exit dispute in 2010. Applying the reasonable...
Can I interrupt you for a second? You're quoting right now Tidewater versus Venezuela, and this is an exit case. Isn't it so that exit convention has a different standard for the challenges?
Mr. Arbitrator, we're using an exit case here because the facts are almost similar, and exit and ancestral tribunals are part of the same dispute settlement system, and therefore they act accordingly. Hence,
Counsel,
we urge this tribunal.
but isn't it correct that the legal framework applicable to the challenges under the ICSID Convention and the legal framework applicable to the challenges under the ancestral rules are
Yes.
different? So
Yes.
the norms governing the rules applicable to challenges are different. Is it so?
Yes, Mr. Arbitrator is right. The precise difference here is the manifest lax standard under the ICSID Convention, and we argue that that manifest lax standard has almost similar wording to the justifiable doubt standard as set out in this dispute. Hence, this tribunal should be persuaded by that reasoning.
And what is manifest lack of impartiality standard under the ICSID? What the standard applicable under the ancestral rules? Like, what are the similarities and what are the differences between those two? That would warrant the application or warrant invocation of the Tidewater case in this context.
The similarities between these two is in the manifest lax standard and justifiable doubt standard. It appears that an appearance of bias on the side of the arbitrator is enough for a challenge to be upheld in both the ICSID Convention and under the ancestral arbitration rules, Mr. Arbitrator.
So you are saying that under the ICSID Convention, an appearance of bias would be enough to sustain the challenge?
Under the manifest lax standard, yes, that is our position, Mr. Arbitrator.
Okay, thank you, Counsel.
The facts of this challenge should not be divorced from their context, which ultimately is that the award in the Hua Plants dispute was rendered due to WellFalcon's implementation of ASNEC's directive, and similarly, the award in this dispute will be rendered based on LAOC's implementation of this directive. The claimant might contend that both scenarios were entirely different. However, the legitimate expectations of the investor, the state's right to regulate, and the issue of whether this measure should be attributed to ASNEC are all matters that were intensively discussed in that award and will similarly be discussed here.
But Counsel, is the party to the dispute the same? I mean, is it the same state which took the measure in the Hua Plants case?
The state that took the measure in the Hua Plants case, Madam President, is WellFalcon, and the state that took the measure in our present dispute is the Republic of Laos. However, yes, we argue that...
Yes, sorry for interrupting, but can we actually see any appearance of bias here? Because maybe this state which implemented the measures in that case was different. The measures themselves might have been different. And will that lead us to the conclusion that there is no similarity between these two cases?
We argue that the similarity between these two cases, the issue conflict between these two cases regarding the 4 particular instances that I have just spoken about, refer to actual bias or an appearance of bias because of the arbitrator's relation with the subject matter in this dispute rather than the parties. It is uncontested that the parties are not the same in both these cases, Madam President.
Counsel, what should be the standard of disclosure? Whenever the facts are similar, then we have to disclose, or whenever the legal positions are same, then we have to disclose, or both of them should be present, then we should disclose?
We should only disclose circumstances that could lead to justifiable doubts under Article 11 of the ancestral arbitration rules.
Okay, you said that the facts are similar. How do you know the facts are similar? Do you have access to that award?
Unfortunately, Mr. Arbitrator, we do not have access to the exact award, but we are relying on paragraph 16 on page 70 of the record, where we see that an article was written about this award, but the award will be revealed to both parties later.
But this article is a newspaper article?
Then yes, it is a newspaper article, but it shows.
So do you want us to act upon the basis of newspaper hearsay evidence?
No, Mr. Arbitrator. We argued that the article shows the general framework of what was discussed in that dispute, and we argue that that will similarly be discussed in this dispute. And since Mr. Mason has already pronounced on that issue, we argue that he should recuse himself from this particular dispute.
But Counsel, it seems like you are walking us down the garden path where you will trap us later on. And by relying on your wordings, if we go by that, then we will breach the confidentiality of that award or that arbitration.
Mr. Arbitrator, believe me, it is not my intention to lead you down that particular road. As I will argue, his appointment in that previous case needed to be disclosed, because when you take it together with his comments and all the other facts surrounding him, he should be removed as an arbitrator in these proceedings.
And what comment was that?
The comment I refer to is the one made on the arbitration podcast, where we see, this is exhibit R8 of the record on page 49. Specifically,
and what did he say that?
Specifically from line 1229 to line 1234, where he says that he does not see how climate change adds anything new to the debate in investment law. And ultimately, he states that when we're looking for the correct opinion in a case, we need to look at the side of the investor. We need to understand the project from the financial side in order to come to the correct solution of a dispute. Hence, we argue that he is biased to one of the parties in this particular dispute, as he wants us to focus particularly on the investor side.
Does it matter where and in which context he gave this statement?
Yes, it does matter. And we are of the opinion that an arbitrator should not be challenged for expressing abstract views in academic papers or interviews, as that would limit what can be said in this field of investment law. However, we are of the opinion that these comments, when taken together with every other circumstance surrounding him, show that he is partial, Mr. Arbitrator.
So, Counsel, that no arbitrator can be professor and professor cannot be arbitrator, then they cannot give a speech. They can't. I mean, it seems like you are offering or you are issuing a gag order.
No, Mr. Arbitrator. It is possible for an arbitrator to be a professor. However, as it was held in the CC Devas versus India Ancestral dispute in 2012, arbitrators are entitled to have their views on legal matters, while the respondent is equally entitled to have its argument heard and ruled upon by arbitrators with an open mind, and the right of the latter should prevail.
Can I also ask a question?
Yes.
So basically, right now, it seems to me, and correct me if I'm wrong, that you are saying that there is an appearance of bias on behalf of, on Mr. Perry Mason's side,
yes.
which is basically established on the basis of blog post, which you admit is not a self-sustained reason to grant the challenge, to satisfy the challenge, and also a newspaper publication, which does not offer any insight as to what was the reasoning in that award and how the effects in the Hewar Plans case were similar or not similar to the case that we are now hearing in this proceeding. So those two grounds separately, if they're like the second one, meaning the publication, without knowing what's in there, we also cannot basically cannot establish whether there is a ground for challenge and there is an issue conflict for sure. And you're basically asking us to view this whole situation cumulatively and come to the conclusion that cumulatively all those facts point to the conclusion that Mr. Mason has an issue conflict. Is that correct?
Yes, Mr. Arbitrator.
Okay, but how can one align it with, first of all, with the jurisprudence, and second of all, with general logic? Because from how I think it can be approached, you can look at it as two separate facts, which individually do not grant or do not cannot be used to challenge someone. And if they individually cannot be used to challenge someone, why they together should amount to a reasonable ground for a challenge. So it's like, out of two zeros, if you sum them up, the result is zero. Yeah. Yes.
Mr. Arbitrator, we urge this tribunal to take them into consideration altogether, because in the National Grid PLC versus Argentina dispute under the ancestral arbitration rules in 2007, it was held that when we are challenging an arbitrator, all the circumstances surrounding him need to be taken into consideration for a challenge to be considered. I will now move to the first.
But are there any other cases? I'm sorry, last question for you. Are there any other cases apart from National Grid, more recent ones, that would advocate in favor of this cumulative approach that you are putting forward?
Perenco versus Ecuador, Mr. Arbitrator. Yes.
Perenco, okay, let's see.
I believe that is.
But Perenco is a mixed case.
Yes.
So you're basically saying that we should draw parallels here with the ICSID framework.
Yeah, just the reasoning, Mr. Arbitrator.
I see. Thank you very much, Counsel.
I will now move to my second submission under my second point and ask that this tribunal finds that it does not have jurisdiction to hear the dispute submitted by the claimant, Goliath National Bank, for two reasons. One, this tribunal lacks subject matter jurisdiction because the claimant has not made an investment. And two, this tribunal lacks personal jurisdiction because the assignment agreement is invalid. With respect to the first argument, the respondent asserts that an investment was not made by Goliath National Bank. This is because investments must be associated with an economic activity in the energy sector pursuant to line 1614 of the ASNEC Energy Investment Treaty on page 61 of the record. The claimant might contend that it financed the building of a coal power plant, and hence it met the requirement of financing an economic activity in the energy sector. However, we argue that this financing was in no way related to the financing of the loan required to construct the coal power plant in Tikedia, and as such, the requirement of association is not met. The financing provided by the claimant here was made in a bid to cushion its predecessor, the Mercuria First National Bank, following Tikedia 1 LLC defaulting in repaying the loan. According to paragraph 29 of the Statement of Uncontested Facts on page 60, it would seem that the primary function of this sale was to help MFNB avoid insolvency, thereby keeping MFNB afloat by trying to rehabilitate that enterprise through the payment of $150 million, which would solve MFNB's liquidity issues, but would not constitute an investment.
So, Counsel, what is your position regarding the investment that the claimant has? What is it exactly? Or you're claiming that the claimant has absolutely no investment?
Yes.
Counsel, but
yeah, sorry.
Yeah, Alexandra, I'm sorry. Please go on, Alexandra.
Yeah, my question was that, as I understand from the facts of the case, it is not contested that the predecessor actually had an investment and it was a loan. So why would a person who buys an investment from someone being assigned of the claims is actually like a purchase of the claims? Why would this person not have an investment? What is the difference here?
Madam President, as per our second argument, we argue that the assignment agreement here is invalid because the predecessor of the claimant, which made an investment, the Mercurian First National Bank, did not have the consent required from the host state to assign and transfer the treaty claim it purported to under the assignment agreement on page 23 of the record. The treaty claim is...
can I ask you something first of all?
Yes.
If you go to the assignment agreement that you're now talking about, the para 1.1 says that the seller hereby assigns and transfers all the rights and claims, whether under domestic or international law, arising from the financing agreement to the purchaser. And then you're saying basically that there needs to be consent to an assignment, and there needs to be also probably separately a consent to the jurisdiction of the tribunal, right?
Our argument here is that there needs to be consent for an assignment of treaty claims. And this is because it would be surprising if states had intended to allow investors to freely transfer rights such as these in an area that is particularly sensitive and closely linked to the issues of sovereignty. Even if such a transfer was limited to an investor's co-nationals, as the transfer is here, the Republic of Laos would still lose control over who could assert treaty breaches and bring arbitral proceedings against it. In the absence of clear treaty language to such an effect, it must be concluded that this could not have been the intention of the signatories of the ASNEC Energy Investment Treaty.
But Counsel, isn't it so that if the claim is assigned, basically, and MFNB cannot bring it on itself, and GNB does it instead, that does not really serve the purpose of, or this does not really harm anyhow the investment protection regime, because there's still only one claim, and if that claim validly exists, what's the problem with GNB bringing it and buying it from MFNB? What's the damage to the investment law system?
Mr. Abijeta, I see that I have 8 seconds to conclude and answer your question. May I have 1 minute additionally to answer your question and conclude?
Yes, of course. I think we can give more if my arbitrator is not against it.
Yes, sure.
Yeah.
Something like maybe 3 minutes.
All right. we argue that the assignment here affects the investor-state dispute settlement system because it was concluded in bad faith. Firstly, the notice regarding this assignment was given to the state after the fact. Second, there is an abuse of the process, and this is because the Park Rim Cayman versus El Salvador case in an ICSID dispute in 2009 found that the test we should look at is as follows. When at the moment of the transferor can see an actual dispute or can foresee a specific future dispute, ordinarily, there is a very high possibility that there is an abuse of the process. The transferor here...
But how the effects of the Park Rim case are comparable to this case? What are the effects of the Park Rim case?
The facts of the Park Rim case are there was an assignment from a company in El Salvador to another company outside the jurisdiction of that particular BIT. Hence, the question here was that assignment valid, and was it concluded in good faith? Now,
precisely. And how is it comparable to our situation? Because in our situation, both assignee and assignor are in the same jurisdiction. So there is no bad faith, or arguably there is no bad faith, because they are not trying to get jurisdiction to sue the state. Both of them technically, if the assignment agreement is valid, still fall under the protective scope of the applicable treaty.
Yes. We agree that this transfer here has been concluded with an investor who is of a party that is indeed in the ASNEC Energy Investment Treaty. However, this assignment was concluded in bad faith, Mr. Arbitrator, because as per that test, MFNB could see a future or potential dispute coming against the Republic of Laos following the measures we took. Hence, we argue that this assignment was concluded in bad faith and should be found invalid by this tribunal.
But how is it in bad faith? Pardon me for being so insistent. I'm just curious, and it's really important for me to understand your argument as a whole. So how is it in bad faith if both when MFNB knew of the dispute, it already technically, or one can argue that it had standing to bring claims against Laos, and it wouldn't be anything related to bad faith if MFNB brought, arguably again, this claim against Laos. But when this claim is assigned, this somehow becomes an action in bad faith. I'm just trying to understand where the bad faith element comes from.
Yes, Mr. Arbitrator, it is uncontested in this particular dispute that if MFNB brought these claims against Laos, we would have no problem. However, we argue that such an assignment of rights to another bank in this particular dispute is invalid. Mr. Arbitrator, let us take the example of what this assignment to be transferred to Goliath National Bank and subsequently transferred to 10 other banks. Would it then mean that the Republic of Laos has opened itself to disputes versus 10 other banks who have no relation to the Republic of Laos? This is the question we seek the claimant to answer in this particular dispute, as we argue that this assignment agreement is invalid.
Counsel, let's take your example one step further.
Yes.
Then if we follow your argument, then no shareholder of investor can sue the estate then. So we have many cases where shareholders have a company have sued the government, host government. So how do you justify that?
Mr. Arbitrator, if we are to go by the shareholders in this particular dispute, that would allude to the control test. And we argue that in this case, control in GNB manifests itself in one particular way. All the significant shareholders of Goliath National Bank are from Europe and the United States and would therefore not gain any treaty protection under the ASNEC Energy Investment Treaty.
Why is that, Council? Are there any control requirements in the treaty?
There are no control requirements in the treaty, but in attempting to answer Mr. Arbitrator's question regarding the shareholders, we allude to that particular fact on line 1517, page 60 of the record.
Thank you, Council.
If we agree that the assignment was correct, then your whole argument falls then.
No, Mr. Arbitrator. If you agree that the assignment was correct, we argue that an investment was not made because the investment that Goliath National Bank purports to have concluded here is financing the Mercurian First National Bank and preventing it from going into insolvency due to its liquidity issues. And such such an act is not an investment as per the Arsenic Energy Investment Treaty.
Thank you.
Madam President, I will hand over the floor to my co-counsel as my time is up.
Thank you, Counsel. So I see that you used some additional time. Actually, my watch shows 5 minutes, so your opposing counsel, for the sake of fairness, will also have that additional time. And
Right.
so, counsel for the claimant, the floor is yours.
Thank you, Madam President. The President, honorable arbitrators, I am Ajibade Shalom, and with my co-counsel Olufolaji Otitola, I represent the claimant Goliath National Bank in today's proceedings, and in the space of 19 minutes, I'll be addressing the procedure of the dispute in the order it is addressed by opposing counsel. That is the challenge of Ms. Perry first and the issue of claimant standing second. Honorable arbitrators, we are here before you today because respondents, through extreme measures, frustrated the loan investment of initial investor MFMB, forcing it to assign its rights to current claimant in order to avoid insolvency. After putting MFMB under such a challenging situation, respondents still challenges both the standing of the claimant and its nominated arbitrator in these proceedings. We therefore submit that this tribunal find that first, Ms. Perry should not be removed as arbitrator in these proceedings, and claimant has standing to institute these proceedings. And beginning with the challenge of Ms. Perry, while opposing counsel has argued that there are justifiable doubts as to the impartiality and independence of Ms. Perry, claimant has two responses. First, there are no justifiable doubts as to his impartiality and independence, therefore they could not, and secondly, there could not be a duty of disclosure in the first place. As to the first argument, while counsel recognizes that under Article 12 sub 1 of the Uncitrall Arbitration Rules, an arbitrator may be challenged if there are justifiable doubts as to impartiality and independence. However, the threshold for challenging an arbitrator simply for a previously expressed legal opinion is very high. And even in the IBA guidelines referred to by opposing counsel, the guidelines do not even impose a duty of disclosure upon legal opinions that are not made as regarding the case directly. Further, in the view of a reasonable person, the International Investment Arbitration Framework will cease to be viable if arbitrators are simply removed for serving on previous tribunal that had examined the same issues or treaty. Therefore, this was also the concern in Vattenfall versus Germany. Therefore, relying on the ASIL...
How Vattenfall versus Germany is relevant here? Vattenfall is an exit case. And if you're invoking some facts or some decisions on the challenges there, please, could you let us know which particular decision are you invoking, the first challenge or the second challenge?
Thank you. I was just making reference to the concern, the particular statement of the tribunal, which is general to the whole international investment arbitration climate. And Mr. Arbitrator, if I may make use of the ASIL ICCA task force on international arbitration issue conflict, which is a report that is based on the review of existing guidelines and available disqualification decisions and should be instructive in this case. Therefore, if there is to be found that there is an issue conflict, respondent ought to prove that first, there is a degree of specificity and a degree of commitment to the particular idea or statement or position alleged to the arbitrator. And that is not met in this case. In proving that, okay.
Yeah, counsel, I have another a follow-up question, which kind of goes to the same direction as my first question. Counsel for the respondent has said in his pleadings that the applicable standard under the Uncitrall rules is very similar to the applicable standard for disqualification under the Exit Convention. And because of that, some cases or some decisions on the disqualification rendered under the Exit framework can also be used to support the arguments for disqualification of Mr. Perry Mason in this case. So would you agree that the standard for disqualification under the Exit case is similar to the standard under the UNCITRAL rules or not?
Thank you, Mr. Arbitrator, for that question. And counsel agrees with opposing counsel that other cases from other institutions may be adopted by this tribunal to take into consideration the fact of the present dispute. And based on that, upon a review of the past disqualifications tribunals, the ICCA ASIL task force has come with two requirements of specificity and degree of commitment to an idea. And in proving that the statement of Mr. Misimperi does not match this requirement, counsel refers this honorable tribunal to page 45 of the case file, which is particularly the challenge of Misimperi by respondent, particularly paragraph 6, which contains the specific concern of respondent as regards the statement of Mr. Misimperi in the podcast as reported in page 49. Respondent's concern, as seen in that passage, is the fact that Mr. Mason has made generalizing references to particular set of cases and not others, where the tribunals have held that environmental law should supersede investment rights, means that Mr. Mason does not consider environmental law as a relevant argument. Members of the tribunal, it is hardly logical nor appropriate to base the requirement of specificity on a statement, on an inference made by respondent from the statement of Mr. Misimperi in order to suit his challenge. And as correctly pointed out by Mr. Arbitrator, the context of the matter should also be taken into place. As seen in page 49 of the case file, which is the particular statement of Mr. Misimperi, the last paragraph of his response shows that it was not even an in-depth legal analysis of the complex issue. Instead, it was a mere advice to young arbitrators and practitioners as to their career path.
Counsel, before that argument was run by, or the question was asked by me, the counsel for respondent has argued that in the previous case, Mr. Mason was dealing with the similar facts and similar legal issues. That is his main challenge.
Thank you, Mr. Arbitrator. Respondent's concern, although is recognized by counsel, but if given into by this tribunal, no arbitral tribunal will ever be formed, considering the fact that the reality of international investment arbitration is that arbitrators will get to meet the same treaty and the same wordings over and over and similar facts in different cases. And that also shows for expertise, which is also a pillar of international investment arbitration. Therefore, for such a challenge to be upheld, respondent ought to have proven that there was a degree of commitment to such a position.
So, counsel, is it your position that an arbitrator can be appointed several times, many times, on the similar facts and similar treaty and similar issues, and you will have no objection to that?
Thank you, Mr. Arbitrator. Our position is that for the arbitrator to be removed, it has to be shown that he has taken a consistent view in all of these tribunals he has been present on. And in the case relied upon by opposing counsel, the CCD Vasquez versus India, which is an UNCITRAL case, the challenge arbitrator was removed because he has assumed a consistent arbitration, a consistent approach in 4 different tribunals and has even backed this up in an academic article. This case shows that for there to be disqualification based on past cases, there has to be a consistent show of commitment to a particular idea, and the fact relied on by the respondent in this case cannot meet that threshold. As seen in paragraph page 70 and 50, respondents relied on the cases of Well-Falcon versus Well-Falcon and EWAS plant, CNRG and EWAS plant. As pointed out by Mr. Arbitrator, these awards are not even published. Respondents even pointed out a social media post which merely described the case as groundbreaking. This statement does not even evince a particular idea about this case. Therefore, it cannot be said that Mr. Mason has a commitment to a particular idea in this particular case. Therefore, it cannot be, and even if under the IBA guidelines, which has been relied upon by opposing counsel, there is no duty to disclose a past arbitral tribunal based on similar fact or issue, except the particular parties, one of the particular parties is a present to the present in the present dispute, is a party to the present dispute. And that was also what was held in Kazakhstan, that was Karatu, where the tribunal excluded the challenge arbitrator because of the information he got about Kazakhstan in previous arbitral tribunal which he served. So with this, respondent concludes that claimant concludes that respondent has not matched the threshold to remove Mr. Mason in this particular case. I will now conclude that this tribunal find that there was no justifiable doubt as to his independence and impartiality, and under Article 11 of the Ancestral Arbitration Rules, only justifiable doubt and circumstances which arises are to be disclosed in such order. Therefore, since there are no justifiable doubts in the first place, there was no duty of disclosure. And this tribunal...
Counsel, as a professional duty, as a professional standard, isn't it the arbitrator should, in good faith or in professional way, he should have said that I have sat in similar treaty or similar case before? He just have to declare that. What's wrong with that? He could have said that.
Thank you, Mr. Arbitrator. But the arbitrator, Mr. Perry, is under obligation by the KCAB rules, which is also applicable due to the institutional which is taking control of this dispute. He has a duty of non-disclosure. Is meant a duty of confidentiality as regards the cases, and this is also backed up in paragraph 17 of the fact, where the party of the procedure order 3, where the parties even made it clear that they are not to disclose any of the details of the tribunal until the award is released. And this concludes claimant's argument on the challenge of Mr. Perry, and this tribunal is implored to find that Mr. Perry should not be removed from the tribunal. And I will now proceed to the second issue, which is the standing of claimant. In demonstrating the basis of claimant standing, counsel refers this honorable tribunal to page 23 of the case file. Page 23 is Exhibit C12, which is the assignment agreement between MFMB, the initial investor, and GNB, the current claimant, particularly clauses 1 and 2, under which claimant purchased all of MFMB's rights and potential claims over the Tikadia 1 loan for a sum of $150 million. While the respondent has argued that this does not amount to an investment and the assignment was invalid, counsel argues that first, the purchase of loan qualifies as investment under the treaty, and second, the assignment was not prohibited, and third, the transaction was not carried out in bad faith. As to the first argument, counsel refers this honorable tribunal to page 61 of the case file. Page 61 is the Arsenic Investment Treaty, particularly paragraph 1, which articles 1, which defines investment. Members of the tribunal, particularly articles 1 sub 1A and C. Under article 1 sub 1A, investment includes pledges, and articles 1 sub 1C clearly stated that investment includes claims to money, and it has been recognized in a plethora of awards, notably FIDAS versus Venezuela, that loans and loan rights amounts to claims to money. And
also, can I interrupt you for a second?
Yes.
Let's approach the problem from a bit of a different standpoint. If we, as a tribunal, are to conclude that the assignment agreement is valid, is it really necessary for us to go into an analysis of whether GNB made an investment? Or we can just basically satisfy us with checking whether MFNB made an investment and can be qualified as an investor under the applicable treaty? Or we need to check whether both MFNB and GNB can be qualified as investors, and can their investment or their capital stream can be qualified as an investment under the treaty.
Thank you, Mr. Arbitrator, for that question. And counsel points out that your concerns understand the question of Mr. Arbitrator. And under the treaty, as seen in the same page 61, if I may direct this honorable tribunal to paragraphs line number 1613, which particularly shows that a change in the form in which assets are invested does not affect their character as investment. With this, and which is also the reasoning in Aplat versus Argentina, the fact that the loan, the MFMB's loan to Tikadia 1 was assigned to current claimant GMB does not change its status as an investment in the hands of the current holder. And this, we have the effect of substituting MFMB for GMB. Therefore, MFMB is out of the picture and only GMB may sue respondent state. Then this brings me to my second argument, which is...
Council, Madam Chair has a question, and then after that, I have a question on this point. So,
Okay.
Madam Chair, you can go ahead.
Yeah, thank you. What I wanted to ask was the reference to paragraph 1C of Article 1. It says not just claims to money, but it says claims to money associated with an investment. Does this mean that there needs first to be an investment and then there needs to be claims to money associated with such investment? Because here you seem to say that there are claims to money and there are in themselves investments.
Thank you, Madam Arbitrator. In answering your question, Council refers to paragraph 5 of respondent's response to the notice of arbitration, which does not dispute the fact that MFMB's loan to Tikadia was an investment and does not even does not dispute the fact that Tikadia 1 plant is an invested. Therefore, while it has made in a plethora of awards that loans and loan rights amount to claim to money, and since, in fact, this loan was associated with Tikadia 1 project, which respondent has clearly recognized as an investment, therefore, claimant's rights in this particular dispute will amount to an investment. Thank you.
Thank you.
So on the same point, when you are there, just I want to know, legally, assignment of agreement and purchase of loan, are these two same?
Thank you, Mr. Arbitrator, for that question. From the point of view of the initial investor, it will be an assignment of the loan, while from the point of view of the current claimants, which paid a consideration for getting the right, it will mean a purchase of the loan. So it's just
no, I want to know. I want to know your position on that. Do you think legally assignment of agreement and purchase of loan are the same thing? What's your position on that?
Council has the view that they amount to the same thing. However, the assignments, the only difference might be that assignment may contain more rights, specific rights, than the loan itself. So it depends on the particular arrangement.
So in your arrangement, in your arrangement, is it an assignment of agreement or is it a purchase of loan?
It is both, Mr. Arbitrator.
Both, okay.
Thank you. And coming to my second argument, which is the assignment was valid, while opposing counsel has pointed that the assignment was invalid, counsel argues that so far the prohibition of assignment of treaty claims is not present in any of the applicable laws, it cannot be held that the assignment was invalid. Even in the present disputes, the ASNEC Investment Treaty provides in its fourth preambular clause, which is to encourage, sorry, Mr. Arbitrator, if I may refer Honorable Tribunal to page 61, the same ASNEC Investment Treaty. Which is the second preambular clause, which provides that having regards to the importance of sustaining economic growth and development in the ASNEC region through joint efforts in promoting intra-ASNEC investment flows. In fact, under this preambular clause, the ASNEC Treaty, one of the purposes is to facilitate investment flows. And this agreement, the treaty, does not even prohibit assignment of rights. Therefore, to find that claimant lacks standing because it is an assignee of MFMB's rights, we read into this treaty a prohibition that does not exist. Council sees that it's out
respondent. Sorry, respondent said that this assignment is not valid because the host government did not give the consent for this assignment.
Thank you, Mr. Arbitrator. Council sees that it's out of time and seeks an extension to answer Mr. Arbitrator's question.
Sure.
Thank you, Mr. Arbitrator. If I may refer this tribunal to paragraph 5 of the procedural order 3, which is page 67. Page 67, paragraph 5. It shows that upon the assignment of the right, the respondent states were made aware of this arrangement a day after the execution, and they did not in any way communicate any objection to this arrangement. Going by the reasoning in MNSS versus Montenegro, where a state has received notification of such an act and has not in any way provided any objection until the action is instituted, it cannot be said.
So, Counsel, when this consent has to be given, before the assignment or after the assignment?
That is the, thank you. That is the question of the applicable laws, and respondent has not proven in any of the applicable laws that consent of the whole state is needed for the transfer of this right. Therefore, to reach that requirement is to impute into the applicable laws what was not established in the first place. I hope I have answered your question, Mr.
In response to that question, he said that assignment, even it was done in bad faith. What do you have to say on that?
Thank you, Mr. Arbitrator. And counsel argues that there was no bad faith in this case. And in fact, this assignment is more beneficial to the respondent state based on the fact that both GMB and MFMB are both nationals of Mercuria, which are covered by the treaty, the investment treaty. So GMB is not trying to get a right which MFMB did not have under the treaty itself. Then further, GMB has taken operational risk of getting this loan based on the fact that the plant will still run for 12 years, and for 12 years, that is 12 years of operational risk. And in the spirit of transparency, instead of MFMB considering its economic situation, as seen in paragraph 26 of the fact, it was in dire economic situation and might not have been economically able to institute this claim. Instead of seeking secret financing, it's in the spirit of transparency, assigned the rights and even notified respondents of this assignment. And this cannot be said to be bad faith, members of the tribunal. Thank you for your time.
Counsel, I have one more question regarding the way this assignment was made. So this right to bring a claim against the state, it stems from the ASNIC Treaty, which is an international law treaty. And here the parties purport effectively to assign this right, this claim under an international treaty by way of a private assignment, this assignment agreement between two private parties. So do you believe there is a problem with that?
Thank you, Madam President. There is no problem with that in the view of counsel, and it is even acknowledged in a plethora of awards, notably RNS Investment versus Serbia and Venezuela Holding versus Venezuela, that there is no general principle of property law in international law. Therefore, the role of international law in investment is to recognize the property created and defined by national law, and then to draw from that whatever consequences may flow on the international plane. Therefore, while the execution of the financing agreement, the rights created are under the treaty, the financing agreement itself is a subject of municipal law. I hope I have answered your question, Madam President.
Yeah, thank you.
Thank you.
So if that concludes the submission, then we can pass to the rebuttal, and Sir Rebuttal, the respondent, the floor is yours for the rebuttal.
Thank you, Madam President. Members of the tribunal, proximity to the case, degree of commitment to the statement or idea giving rise to the challenge. These are the standards the claimant has relied on to prove that there is no issue conflict. However, we argue that Mr. Mason was part of the tribunal that rendered the award in the Hua Plans case, and it showed a degree of commitment to the idea that gave rise to this challenge, which is he does not consider environmental law arguments relevant. Secondly, our challenge here is not solely premised on the Hua Plans dispute. Our challenge here is premised on all the circumstances taken together. And we argue that when we view all of them taken together, there is an apprehension of bias. And under Gayo versus Canada, the ancestral dispute in 2007, This is enough for a challenge to be upheld. Lastly, it is uncontested that arbitrators face similar disputes. However, we argue that such a finding by this tribunal that he is biased is not against the investor-state dispute settlement system and should only be done out of an abundance of caution, because if it is not, a fair hearing of the respondent's case would not be possible, as this dispute is fait accompli in Mr. Mason's mind. This concludes my rebuttal. Thank you, members of the tribunal.
Thank you, Counsel. So now it's time for the claimant, if you have anything in response.
Thank you, Vito. Claimant has one point of response to all the rebuttals raised by opposing counsel, which is, while there may be an apprehension of bias, but for legal opinions and for past arbitral tribunals, there ought to be a degree of commitment to these ideas before this can be proven. And respondents, the facts relied on respondents are hardly enough. The EWAS plant case and the C Energy case are not even published yet. So why do we challenge an arbitrator on an award which he has expressed an idea and the award has not been released yet? Thank you for your time.
Madam Chair, before we move to the other stage, I have a question for both counsels. According to the KCAB rule, which they have agreed, assuming, or I agree that I am Professor Mason and you are challenging me, this argument should have been presented before the two arbitrators, not before me, but you have presented before me. So one question, can I decide this issue also? And the second, if you have argued against my disclosure and conflict of interest, do I have a right to respond to you or not?
Should I go?
Yeah.
Both counsels.
Okay.
You can go first, it's fine. It's fine.
Okay. Under Article 13 of the Unsexual Arbitration Rules, if you were missing Perry, Mr. Arbitrator, you do not have any rights to decide on this matter. Then further, the arbitrator has a right to provide a statement, and this has been done by Mr. and Mrs. Perry in, if I may refer this tribunal to pages, sorry, Mr. Arbitrator. Okay.
So counsel, I understand that, but then why did you argue on my behalf?
Yeah, you already created the statement. You already released a statement to that effect to clarify the issue, and it is contained in the case file, which is particularly.
Yes. So did you act as my lawyer?
52.
So counsel, did you make this argument on my behalf?
You already made argument on your behalf, sir. Okay. And it is our point to just based on your argument and the relevant laws and relevant facts.
I want to hear from the respondent.
Thank you, sir.
With regards to your second question, Mr. Perry Mason can file a response to the respondent's challenge. And I believe the page that the claimant was alluding to was page 52, where he has done this. With response to your first question, which was whether Mr. Mason can sit in this tribunal, I believe, we argue that as per the maxim in civil law, nemo iudex in sua causa. Essentially, no one can be a judge in their own cause. Thank you, Mr. Arbitrator.
Thank you.
Thank you, counsel. So if there are no further questions from my co-arbitrators, then I believe we can pass to the merits submissions and the counsel for the claimant on the merits. Whenever you are ready, you have the floor.
Thank you, Madam President. The presiding arbitrator and distinguished members of the tribunal, my name is Olufolaji Mutitola. I am appearing as counsel for claimants on the merits. Members of the tribunal, in 2010, Mountain Top and MFMB decided to make investment in Laos by constructing a coal power plant that began operation in 2014. This was after consistent representations had been made of a favorable legal climate by relevant authorities in Laos. But barely 2 years after operations began, the respondent fundamentally changed its regulatory regime. And although it is the respondent that made representations to the claimant, to the initial investors, it is the initial investors that have paid for this representation. The respondent has further gone on to state that the actions it has carried out are not attributable to it. In the following 19 minutes, I will demonstrate that the respondent is responsible for the measures taken to phase out coal energy in the state, and that secondly, the respondent has violated core principles of fair and equitable treatment under Article 2 of the ASNEC Energy Investment Treaty. On the first issue, claimant submits that the measures taken to phase out coal energy in the respondent state is attributable to the respondent. Claimant would like to draw the attention of this Honorable Tribunal to page 33 of the record. This contains the ASNEC founding charter under Exhibit R3. Under Article 120, it provides that attribution of conduct will be particularly governed by the provisions of Articles 6 and 7 of the Articles of the Responsibility of International Organizations. And claimant submits that the conditions under Articles 6 and 7 are not met in this case, and consequently, attribution is on the respondent. In relying on the articles, it is important that I state first that the commentaries on these draft articles are used to interpret the draft articles. And claimant submits first under Article 6, which provides that an international organization acts through its state organs as well as its agents. Claimant concedes that the respondent state in this case might have acted as an agent on behalf of the international organization. This is based on the definition given by the ICJ in the reparations for injuries case, when it stated that an agent is anyone through whom an international organization may act. However, it is claimant's submission that the particular measures taken in this case are discretionary actions of the respondent state. Claimant indeed recognizes that states are not responsible for the actions of an international organization purely based on membership. Neither are they responsible for carrying out their obligations as members of the international organization. But as consistently held by the European Court, in cases where it was interpreting the legal obligations flowing from international organizations, it stated that where member states are given a level of discretion in carrying out obligations as members of an international organization, the state will be held liable for any breach that occurs in the process. This principle is known as the Bosphorus test, and it was applied in the Bosphorus case when the European Court particularly stated that where a particular positive act is left at the discretion of the respondent state, it becomes a domestic act, which the state will be held liable for if a breach occurs. Claimant will show that the respondent had discretion in carrying out his obligations under the ASNEC directive.
Counsel, sorry to interrupt. Regarding the test that you apply here, could you please repeat for this tribunal where it was elaborated and why you believe this test can be applied in the present answer trial proceedings in investment arbitration?
Thank you very much. It was applied in the case between Bosphorus Harbor Eulari versus Ireland, which is a 2005 case before the European Court. We believe that this test applies in this case based on the fact that where agents of an international organization act, where it is based on their own discretion, it cannot be attributable to the international organization in itself.
And are you aware of any investment arbitration cases which dealt with the same issue, with the issue of attribution of actions to an international organization?
No, Madam Arbitrator.
Okay, thank you.
Thank you very much. In showing that the respondent state had discretion in carrying out his obligations under the ASNEC directive, claimant will first rely on the provision of Article 115, paragraph 3 of the ASNEC founding charter, which is in the same page claimant relied on earlier. It provides that a directive shall be binding as to the result to be achieved, but it leaves the national authorities with the discretion as to the choice of form or method to be taken. This discretion is given under the ASNEC directive in pages 16 and 17 of the record. As reading a joint interpretation of Articles 3, 7.2, and 7.4 show that the member states are allowed to apply their discretion based on their special circumstances to gradually phase out coal energy generation and provide incentives for integration into renewable energy before 2028. This language clearly shows that the respondent state had discretion in carrying out its obligation. And claimant is aware of this discretion, which is why, despite the fact that Article 7, Paragraph 3 gives them the obligation not to compensate, we do not bring this action under Article 3 of the Arsenic Energy Investment Treaty because that shows elements of expropriation, and they did not have any discretion to carry out that action that was binding on them. But what we do contend is that the measures they took in carrying out the directives where they had discretion is a violation of Article 2 of the Arsenic Energy Investment Treaty, which brings up principles of fair and equitable treatment on the part of the respondent states. To further add to this, yes, Mr. Arbitrator, you are muted, Mr. Arbitrator.
You can hear me now. I thought that I'm
Yes.
the naughty arbitrator who has been challenged, so I should be quiet now. But I'm back. On the point of discretion, are you saying that whenever there's a discretion, it should not be applied according to the charter or according to the arsenic, the organization?
Thank you very much for your question. If I understand your question well, our submission is basically that since Article 120 provides that whatever attribution may be made to the international organization, it must be governed by the provisions of Article 6 and 7 of the Articles on Responsibility of International Organizations. And based on an interpretation of it, then will the tribunal find a decision to either hold arsenic liable or the respondent state in this case. Have I answered your question, Mr. Arbitrator?
No, but I want to see that how do you interpret this discretionary power? How do you want them to apply?
Thank you very much.
Is there any rule behind that? Is there any rule behind that? Is there any policy behind that?
Indeed, there is none, because it is the state who is to apply its own discretion. And we submit that they haven't applied it in a fair and equitable manner in this case to favor investors.
Okay.
Thank you very much, Mr. Arbitrator. To further add to this, Article 18 of the directive gave a sufficient time of 3 years for the respondent state to apply its laws to give effect to the directive. However, the respondent state made Law 66/2016 just 3 months after, and then Law 72/2016, few months after the initial law, which under Article 3 of the latter law, which is at Law 72/2016, it gives priority access to the national grid, renewable energy generators constructed in March 2016. The direct implication of this is that it will affect the profitability of coal power plants in the state. And the implication of this has already affected Tikadia One, as they indeed seek to file for bankruptcy in the state. And we submit that based on the fact that the measures were taken at the discretion of the respondent state, it is the respondent state that should be held liable for it. On the second provision, which is Article 7, it provides that a state organ which is placed at the disposal of an international organization will be held, the international organization will be held responsible for the actions of the state organ. However, the provision of Article 7 creates a test, the effective control test, which the European Court has also interpreted in Brahimi and Brahimi versus France to state that the international organization must have ultimate control over the state organ. Members of the tribunal, having submitted that the state had discretion in carrying out its action, it simply means that the international organization did not have an ultimate control over the actions carried out. Therefore, we submit that the provisions of Article 3, Article 6 and 7, which are the provisions used for attribution of conduct, have not been fulfilled in this case. Therefore, LAO is the actions carried out are attributable to LAO in this case. And if there are no questions, yes, Mr.
Counsel, so in that case, so host country has no obligation towards the international organizations at all?
They have, Mr. Arbitrator. Indeed, we recognize that they are to carry out their obligations as members of international organizations. But what we do submit is that where the international organization gives them the discretion to carry out this action, they will be held liable for whatever action occurs, because the international organization cannot envisage whatever level with which they would carry out this discretion. Therefore, the state itself should be held liable.
So, Counsel, then the question comes, at the time of assignment, you give the host state the information about it. So as a matter of good faith, should you not even give the information to the international organization then?
Thank you very much, Mr. Arbitrator. As a matter of good faith, indeed, no, because the investment was made in the host state, and it is the host state's concern, whatever action it is that it carries out that would affect its investors, and not the international organization, as the international organization is just a third party, which the host state is merely carrying out its obligation as a member of it. Thank you very much, Mr. Arbitrator. And I'll proceed now to my second issue.
Just before you proceed, regarding the precedents, it has already been mentioned here today that there, in fact, has been an award in Hua plants. And actually, I see from page 50 of the case that that tribunal ruled that international responsibility should be attributed to ASNEC. So what should we make of this? Should we somehow take this approach into account?
Thank you very much, Madam Arbitrator. Indeed, we note this inquiry, but based on the fact that we don't have access to an award where a proper analysis of why the blame is given to the international organization is not given in detail, we cannot just take the decision in vacuum and apply it in this case. Therefore, we submit that you should address this case based on the special circumstances.
But counsel, be careful. Yes. Your co-counsel has argued on the same case. He has said that similar facts, similar issues, so therefore I should be resigned. No. And now you're saying that you don't want to use that legal argument or the legal reasoning from there.
Thank you very much, Mr. Arbitrator. What he submitted is that based on the fact that it's a similar treaty, and yes, indeed similar facts, but where there's not similar information in both cases, whereby it is the same state party that is that the action is instituted again, then you can sit as an arbitrator.
Now I hear completely different argument, counsel.
No, but Mr. Arbitrator, indeed is not different. What we are submitting is that based on his expertise, he can sit. But we are also submitting that the tribunal should adjudge this case based on its circumstances of the case, rather than wanting to take in vacuum a decision where we do not have analysis of the award in itself.
Okay.
Thank you very much. And I proceed now to my second issue, which is we submit that the respondent state has violated Article 2 of the ASNEC Energy Investment Treaty. Members of the tribunal, Article 2 provides that contracting parties shall at all times accord fair and equitable treatment to investments of investors. And the latter part of this provision makes reference to international law. Therefore, the standard that will be applied in this case will be that made based on the circumstances of the case and that of customary international law. We submit that the standard of fair and equitable treatment is an absolute and non-contingent standard, and the respondent has violated two core principles of fair and equitable treatment in this case. First, they have frustrated the legitimate expectations of the initial investors. And secondly, the actions are arbitrary. On the first submission, claimant recognizes that a state has the right to regulate it or make its own laws. And by no means do we come here to submit that legitimate expectations based on a stable legal climate means that the law should remain the same. Rather, what we submit in this case is that the right to regulate does not extend to the fundamental alteration of the legal regime in the respondent state just 2 years after the operation of TICADIA 1 began.
Counsel, can I interrupt you for a second? What are the legal preconditions for the invocation of the concept of legitimate expectations and the fair and equitable treatment standard?
It basically, we take into consideration the legitimate expectations of the investment and of the investor at the time of the investment itself. And in recent tribunal holdings of the ICSID tribunal, it has recognized that sometimes states might want to switch to renewable energy sector and has placed the obligation of regulatory diligence on the investor. However, what is the basis for legitimate expectation? What can serve as a basis for a protected expectation and the fair and equitable treatment? In this case, we have two grounds. One, the legal climate at the time of the investment, And then secondly, representations made by the respondent state.
Okay.
As
And,
regards
do you think that legal climate as a separate ground can serve as a basis for legitimate expectation? So when you, as an investor, invest in a state, would you be protected, or would your expectation that the legal framework in that state would remain completely unaltered, be protected under fair and equitable treatment? Is that what you're saying? Or
No,
there are some shades of gray in that argument?
We're not saying that. What we're saying is that firstly, under the first submission, that stable legal climate can amount to legitimate expectations. But to add to this, a representation by the respondent states can further establish the legitimate expectations of the investors.
All right. And what were the representations in this case?
Thank you very much, Mr. Arbitrator. Under the third procedural order, we can see that the governor of Ticadia is the constituted authority who can go out to seek investment for the state, as he is given the permission by the national laws of the state. And the governor of Ticadia sought investors, and in this case, which is the initial investors of Mountaintop and MFMB, to make investments in the coal sector of the state. Members of the tribunal, I would like to draw your attention to, claimant Exhibit C2, which is page 10 of the record. We can see that there is a meeting between MFMB, the initial investors, and the governor, where the governor made representations as to the fact that they will try their best to make a favorable legal climate for the investment. And to further add to this, in the news article made in the page before this part, which is page 9 of the record, under Exhibit C1, we see that the current Speaker of the House specifically stated that there is no reason to fix something that is clearly not broken, since it regularly contributes to their economy. Members of the
Council,
tribunal,
can I interrupt you for a second? Let's get back to the page 10.
Yes.
And what is the representation that the governor has made to the participants of the meeting here?
Under line 177, it shows that he promised to ensure that all relevant government officials will, within the scope of the competence conferred to them by the Laucan law, be instructed to cooperate with Mountaintop to the fullest possible, to the fullest extent possible, not only during the construction process, but after the launch of Ticadia 1.
Council, but where does it say here that the governor has promised that to the investors that the law will remain unchanged?
We did not say that the law would remain unchanged, Mr. Arbitrator. What we are submitting is that a fundamental alteration which affects the legal climate, which was represented by the governor, Mr. Presiding Arbitrator, in Exhibit C5.
Okay,
in Exhibit C5, which is page 14. Which is page 14.
But Exhibit C5, it's a newspaper article.
Yes,
so,
Mr. Arbitrator. Under Exhibit C5, he made a representation based on the fact that Lauk at that time was the best place to make coal power plant investments. This is because of the coal-friendly policies that exist in the state. Therefore, his representations were based on the laws that exist. If he made these representations, he simply was expecting us to reasonably believe that there won't be a fundamental alteration of these laws. Mr. Arbitrator, my time is almost up. I seek a minute to answer any other questions that may be raised.
Yes, of course, you can have it, but I think we can have like 5 minutes maybe to continue.
Thank you very much. Thank you very much.
I think there are several questions that we would need to discuss yet. So 5 minutes is more than generous here. So thank you, Madam Chairman.
Thank you.
Yeah. So the question that I would like to ask you is that, first of all, with regards to that article that you have just quoted, do you really think that it can serve as a basis for legitimate expectations here? Because it's after all, it's a press statement made in an informal setting by the governor. It has not been made in writing. It has not been authorized by anybody else in the local government. That is the first question. And the second question, if so, were there any arbitral awards in the past which have came to the conclusion that it is possible to perceive the statements, the public statements made by government officials as a basis for legitimate expectations?
Thank you very much, Mr. Arbitrator. Indeed, we understand every of your reservations. Firstly, we do not submit that this statement alone in vacuum is what we use to form, the initial investors used to form their legitimate expectations. We indeed would like to submit that it was a contribution of events. Firstly, the existence of a stable framework for the past 25 years as at 2008 in the respondent state, which was 2 years before the investment was made. A statement by the current Speaker of the Parliament stating that there is no need to change this framework. Thirdly, the governor relying on this framework coming to make representations to the initial investors consistently in 2 meetings and also in a press statement. To further add to this, a license given for 40 years operation. We submit all of this as a collection of events that can reasonably form legitimate expectations. As to simply hold that legitimate expectations should not have been had on the part of the initial investors would mean that no long-term investments should be made in any state based on the fact that there were no statements made. To further add to this, in a Metal-Clad Corporation versus Mexico,
Metal-Clad is a very old case, and it was one of the first cases where legitimate expectations were invoked. It's more than, I think, 20 years old now. Is there anything more recent? Like from maybe from Spain, for example?
Yes, in Sol Badillos versus Spain and Cube Infrastructure versus Spain. These are both 2019 and 2018 ICSID decisions, respectively. It was stated that the threshold for legitimate expectations will be whether the state's regulatory changes were not foreseeable by a prudent investor at the time of the investment. And we submit, based on the contribution of events, that as at 15th December 2010, which is the time of the investment, that legitimate expectations could have been formed. In addition to this, ASNEC, which is the body that the respondent seeks to carry out his actions, was not formed as at 2010. Hence, the initial investors could not have taken into consideration the obligations that the respondent state had because there were none at that time.
Okay.
And we thought that.
But can I just follow up on that? How do you think the circumstances of the Spanish cases, and in particular the cases that you have just quoted, are comparable to our case? Because as far as I know, and correct me if I'm wrong, is in Spain there were a number of factors that were invoked by the investors in support of the existence of legitimate expectations. In particular, in Spain, the government has implemented a special law that was designed to invite the investors in the country and to encourage them to build solar plants. Apart from that, also a number of special state authority issued special licenses for those investors. And in those licenses, it was said that they're entitled to a specific benefit. Whereas in our case, it's a bit probably more loose in terms of promises. What do you make of that?
Thank you very much, Mr. Arbitrator. First, based on the fact that the municipality in this case, which is Tikadia 1, was the only municipality that did not have any coal power plant existing, and they required coal energy generation. The Tikadia 1 was going to be the sole energy generator in that municipality. Hence, it could be similar based on the fact that they'll be given special treatment. Secondly, there does not need to be a special law, as the law that exists in the state based on the backing of the parliament can be sufficient enough to make reasonable expectations. And thirdly, we submit that this threshold that was submitted by the claimant is not just the threshold laid down in Spain, in the 2 cases before Spain, but was also relied on in cases before against Italy, Czech Republic, and even Bolivia. And while you would take into consideration the special circumstances, the question would be that the legitimate expectations must be formed based on foreseeable instances. And in answering that question, it would be that based on the instances at the time of the investment, no investor would have foreseen that after 2 years of operations began, there will be a fundamental change in the legal climate.
Thank you, Counsel.
Thank you very much. Seeing as my time is up, I would like to conclude my argument before you.
Counsel, before you conclude, just one simple question. Your whole argument is based on assumption that legitimate expectation included in the fair and equitable treatment. What if we do not agree with you such a broad interpretation of fair and equitable treatment under this treaty? Then what will happen to your case?
We submit that, firstly, that it is indeed applicable in this case based on the fact that the provision of Article 2 makes reference to international law. Therefore, customary international law should be taken into consideration. And under customary international law, it has been held by a plethora of cases that one of the core principles of fair and equitable treatment is legitimate expectations.
Counsel, just one question. Do you argue that protection of legitimate expectations is a part of customary international law?
Yes, Mr. Arbitrator.
Thank you.
Thank you, Counsel. So now the floor goes to the respondent, and so Counsel, for the sake of fairness, you will have at least 25 minutes should you need them, and I think that you will do. So you may proceed.
Members of the tribunal, as introduced by my co-counsel, my name is Mdathir Timami. And without prejudice to my co-counsel's arguments, I would like to take the next 19 minutes to address the merits of this case. Members of the tribunal, parties have gathered here today with totally different incentives. On one hand is the respondent, the Republic of Laos, which is combating the effects of climate change while strictly adhering to the directives issued by the supranational organization ASNEC. On the other hand is the investor, Goliath National Bank, who, despite having been given the maximum amount of time to phase out coal, is still requesting for a frozen legal framework, ignoring the effects of climate change experienced in the ASNEC region in general and the Republic of Laos in particular. As such, we shall make 3 key arguments. First, that the enactment of the law on phasing out coal is attributable to ASNEC and not the Republic of Laos. Second, that in any case, this law did not violate the fair and equitable treatment standard in Article 2.1 of the ASNEC Investment Treaty. And third, members of the tribunal, while enacting this law, the Republic of Laos was exercising its sovereign right to regulate under the exception clause in Article 9.1 of the ASNEC Energy Investment Treaty. With respect to attributability, as correctly stated by counsel for claimant, the Article 6 and Article 7 of the draft articles on responsibility of international organization is the governing law by virtue of Article 120 of the ASNEC Founding Charter. Now, members of the tribunal, Article 7 in particular establishes that the international organization will be responsible for the conduct in question if it exercises effective control over the conduct. However, the articles are vague as to what amounts to effective control. As such, we invite this tribunal to consider the International Law Commission's commentary on the articles for guidance on what amounts to effective control. The reliance on the International Law Commission's commentary has been affirmed by previous arbitral tribunals. For instance, in the United Parcel Services America versus Canada Ancestral Award of 2007 did rely on the International Law Commission's commentary. Now, the International Law Commission's commentary makes reference to a number of cases such as Berami, Al-Jeddah, amongst others. we submit that the International Law Commission's commentary expressly notes that the House of Lords application of the effective control standard as was used in the Republic on the application of Al Jeddah versus the Secretary of State of Defense was what was envisioned by the articles. Hence, the claimant's reliance on Behrami is unfounded. In that case, the court expressly stated that the effective control test entails a factual assessment as to whether the international organization retained ultimate authority, regardless of the fact that the state had operational authority over the conduct. Members of the tribunal, we submit that this test has been met. And to demonstrate this, we begin by directing this tribunal to page 58 of the Statement of Uncontested Facts, paragraph 21 in particular, the last line, which shows that the Laocan delegate to the ASNEC Council voted against the enactment of this measure, of the ASNEC directive. However, she was outvoted, demonstrating that the Republic of Laos could not do much to avoid the enactment of this directive. In any case, even when enacting this law, the Republic of Laos did have the claimants, pardon me, members of the tribunal, even when enacting this law, the Republic of Laos did have the claimants' intentions at hand by giving them the maximum amount of time possible to phase out coal within its territory, as evidenced on page 59, paragraph 23 of the record. Yes,
Consul.
Mr. Arbitrator.
Consul, I asked this question to the claimant also, and they said that host state had discretion, and they were not under obligation to implement that, but they had a discretion to do that, but they did not do that. So therefore, you are responsible for that. So what do you have to say on that, on discretion point?
Mr. Arbitrator, we do recognize that the Republic of Laos did have the choice of form and method when enacting this directive. However, we would like to bring to the attention of this tribunal that the directive itself was binding, and in any event, the little margin of discretion exercised by the Republic of Laos was subject to the approval of the ASNEC Council. And to demonstrate this, I draw your attention to page 34 of the record, Article 124, Sub-Article 3 of the ASNEC Founding Charter, which expressly notes that the ASNEC Council did have the authority to assess whether contracting parties correctly implemented the law, demonstrating that even if the Republic of Laos did have the choice of form and method, it was subject to the approval of ASNEC, and hence demonstrating ASNEC's ultimate authority over the conduct in question.
Okay, so your position is that there was no discussion at all?
Mr. Arbitrator, our position is that the little margin of discretion exercised by the Republic of Laos was subject to the approval, and nothing in the record demonstrates that the ASNEC Council disputed how the Republic of Laos implemented its measure, and hence ASNEC should be responsible for the conduct.
Council, was it possible to refuse to implement these measures? And if so, what would be the consequences for the respondent? I mean, if the respondent already knew that it would violate its obligations under the treaty in implementing the directive, was it possible to somehow opt out of this, even if the ASNEC decided for all states to have this obligation to implement?
Madam President, as evidenced in Article 124, Sub-Article 4, which expressly notes the measures ASNEC Council could take against the Republic of Laos, which includes suspension of all its rights and imposition of a lump sum. Answering your second question, Madam President, the Republic of Laos could not opt out from the ASNEC Founding Charter. This is because the fact that they were members in the ASNEC Founding Charter was the reason why they were part of the ASNEC Energy Investment Treaty, demonstrating that if they were to opt out of the ASNEC Founding Charter and thereby not be members of the ASNEC regional organization, they would not enjoy the protections under the ASNEC Energy Investment Treaty.
So before joining the international organization, was there any understanding that what will happen to your rights and obligation under any contract, any treaty which you have signed before, such as this investment agreement?
Mr. President, the ASNEC Founding Charter came first, And on the basis of the ASNEC founding charter, that was when the ASNEC Energy Investment Treaty was entered into, and hence there was no such agreement. The only agreement was in relation to the rules on attribution of conduct, which are found on Article 120 of the ASNEC founding charter, stipulating that rules on attribution of conduct shall be governed by Article 6 and Article 7 of the Articles on Responsibility for International Organization.
And can it apply retrospectively?
Mr. President,
because your agreement was signed before. Your investment agreement was signed before, and the international organization comes later. So can we apply the charter or obligation retrospectively?
Mr. Arbitrator, the protections the Republic of Laos, the claimant is asserting in the current proceedings are based on the ASNEC Energy Investment Treaty, which came after the investment was made. The investment was made in 2010. The ASNEC Energy Investment Treaty, which has the protections the claimant seeks to rely on, came into place in 2012, and in fact does apply retrospectively.
Okay, that's interesting.
Does that answer your question?
But you don't give me any basis, legal basis, that how it can apply retrospectively.
Mr. Arbitrator, would you please paraphrase your question?
I mean, I just want to know that all these obligations, can it apply retrospectively? Was there any understanding, any agreement to that?
No, Mr. Arbitrator, there was no understanding on the retrospective applications of the law. In any case, members of the tribunal, I will further direct your attention to page 33 of the record, specifically Article 120, line 801, which demonstrates that the association enforces or implements its legal acts through the organs of its member states, demonstrating that in enacting this law, the Republic of Laos was acting as ASNEC's agent. Hence, ASNEC is responsible for the conduct in question. Moving on to the second part of the argument, we submit that the enactment of the law on phasing out coal did not violate the fair and equitable treatment standard in Article 2.1 of the ASNEC Investment Treaty. The claimant contends that the legislative framework in the Republic of Laos could give rise to a legitimate expectation. However, we submit that the claimant fails to take into consideration the recent developments in the investor-state dispute settlement system. Recent arbitral awards, such as Antares versus Czech Republic, a Stockholm Chamber of Commerce in 2018, and PV Investors versus Spain, an ancestral award of 2020, expressly note that a legislative framework that is applicable to many people cannot give rise to a legitimate expectation unless the investor took an active step to inquire the prospects of change in that regulatory framework. Members of the tribunal.
Can I interrupt you for a second? Did you just cause Antares versus Czech Republic, and the second case was which one?
PV Investors versus Spain.
PV Investors versus Spain. So apart from the views that were expressed in Antares and in PV Investors, there's a pleiad of cases that have basically taken a bit of a different spin on the facts, and they were not as strict, I would say. What do you make out of that? In terms of the argument that you are making, that an investor needs to take an active step and inquire the state about the framework.
Yeah, Mr. Arbitrator.
Because this was not done by all of the investors, for example, that invested in PV installations in Spain. But in many of those cases, the tribunal still found the state liable, even though the investor did not specifically, like it did in Antares, write a letter to a competent authority and ask the competent authority about the specifics of the regime and about the duration of the benefits that were accorded to the investors under the regime.
In that case, Mr. Arbitrator, the fact that there was a legitimate expectation was on the basis of other representations made by the state. However, the tribunals expressly noted that a legislative framework that can only give rise to a legitimate expectation if it was specifically tailored for that investor. In our case, members of the tribunal, this law was in place for over 25 years. In such an instance, it was unreasonable for the investor to take to invest in this state without exercising due diligence. To demonstrate that this due diligence was not exercised, we begin by directing this tribunal to page 15 of the record, which expressly notes that from as early as mid-2000s, all other contracting parties of ASNEC had already changed their regulatory framework to accommodate green energy. Furthermore,
Council, but isn't it so that still the investor conducted due diligence? Because on the page 11, line 195, it says that directors have discussed various materials when they made the decision about the investments. And among those materials, there was regulatory due diligence. So you say that it was insufficient or it was poorly done?
Yes, Mr. Arbitrator, because in light of the circumstances we will be presenting before this tribunal, we will show that it was unreasonable for the investor to invest in the Republic of Laos. Now, on page 9 of the record.
How is it, was it unreasonable when the governor of the Republic was chasing investors and asking them to, or actively soliciting the investments? So one can put it in such harsh terms as literally chasing people and asking for money and asking for this plant to be built. So doesn't that shouldn't that impact our assessment?
Now, Mr. Arbitrator, the statement made by the governor of Tikadia was that he would do everything in his power to maintain favorable and stable conditions. On the basis of the specificity test established in El Paso versus Argentina, an Exceed Award of 2011, for a representation made by a person in authority to give rise to legitimate expectation, it must first be specifically addressed to the investor, and second, it must be very specific as to its form and content.
What were the facts in El Paso and how they are comparable to our case? Was in El Paso, were we dealing with general framework or with specific promises to a particular person?
In El Paso, the tribunal dealt with a general legislative framework, but they also made reference to the fact that if a commitment is given by a person in authority, it would only give rise to a legitimate expectation if it was specific to the addressee and specific in terms of its form and content. Furthermore, in Crystal X Goldmine versus the Republic of Venezuela, an Exceed Award of 2016, the tribunal did apply the test in El Paso versus Argentina. In that case, the statement made by the Minister of Trade that an environmental license was due in cause was deemed not to have given rise to a legitimate expectation. This is because first, the Minister of Finance does not have control over the environmental licenses, and second, a statement that the license was due in cause was too broad and simply generic. Similarly, in the facts at hand, we demonstrate that first, the governor does not have any control over the regulatory framework in the Republic of Laos, which was subject to change by the Laocan Parliament. In any case, members of the tribunal, the statement was not specific enough. Simply stating that he would do everything in his power to maintain favorable and stable conditions does not give the specifics of the promise guaranteed.
Council, may I just follow up on that? Is it absolutely imperative for states to make specific representation for the concept of legitimate expectations to be invoked? Because in some cases, arguably, such as our case, one can look at it from a bit of a different standpoint, because first of all, you have to look at the whole picture. So you have the governor who is chasing the investors and asking to build a power plant. You have a country which is historically, to a very large extent, not dependent, but very coal oriented. Let's put it that way. And you would naturally, as an investor, you would not expect this government to dramatically abandon coal in an instance, like it was arguably done here. So shouldn't it also impact our assessment, and shouldn't we think that in such an extreme case, there is no need for specific representation to be made, because a reasonable person is entitled in any way to expect that government, if it would change the legal framework, it would do so rationally and not in the blink of an eye.
Mr. Arbitrator,
no, I'm done.
Mr. Arbitrator, we do agree with your position that first, not only specific commitments can give rise to a legitimate expectation. And in fact, when a tribunal is assessing whether there are legitimate expectation, the overall circumstances need to be taken into consideration. Now, as evidenced on page 15 of the record, from as early as the mid-2000s, all other contracting parties in the ASNEC region were converting their laws to accommodate green energy. Further, in 2008, as seen on page 9 of the record, there was a proposal by the Republic of Laos to change the regulatory framework to accommodate green energy. While we do agree that that proposal was rejected then in 2008, as stated in the Statement of Uncontested Facts, it clearly showed the growing influence of the Laocan Environmental Union. Against such a background, it was only reasonable for the investor to expect that it was only a matter of time before the Republic of Laos would also change its regulatory framework. In addition, yes, Mr. Arbitrator.
Have you answered that question, or do you have to add something to that?
No, I've answered the question.
Okay. So very quickly, like, two questions which I asked them, I also ask you. What is your position on that? In your case, fair and equitable treatment includes legitimate expectation or not? Counsel for claimant has said it is through the customary international law it is included. What's your position on that? And the second, I heard the argument from the claimant. They said that they are not only challenging the change of legal environment, they are also saying that this change has also affected the investment climate. And that is their argument also for the legitimate expectation. What is your position on that?
With respect to the first position, with respect to your first question, it is our position that the fair and equitable treatment standard, as has been interpreted by various arbitral tribunals, demonstrates that one of the many contours of the fair and equitable treatment standard includes legitimate expectation, and hence the need for addressing that expectation when analyzing a violation of the fair and equitable treatment standard.
And it comes from the customary international law?
No.
Does it come from the customary international law?
No, Mr. Arbitrator. It comes from it being an autonomous provision in the Multilateral Investment Treaty.
Okay. And on the second point?
On Mr. Arbitrator, would you mind paraphrasing your second question?
The second question was that their argument was that they were not only challenging the change of legal situation, they are also saying that this change of legal situation has also affected the environmental situation. The investment climate and investment environment. So that has consequence of that. So they said that was also part of the their legitimate expectation, which has been breached here. So what do you have to say on that?
Mr. Arbitrator, as was stated in PV Investors versus Spain, the fair and equitable treatment standard does not mean that the regulatory framework will remain the same, but rather the protection is that there would be no abrupt changes that are not reasonable and do not take into consideration the circumstances of the claimant. Mr. Arbitrator, seeing that my time has lapsed, can I have another 4 minutes to answer your question and conclude my arguments?
You have already answered my question.
In fact, you do have additional time if you need it.
Yeah.
Members of the tribunal, we will demonstrate that in enacting this law, the Republic of Laos did not act in an unreasonable way. As seen on page 34 of the record, there was existing scientific evidence that proved that coal emissions were the direct cause of floods in the Republic of Laos. While we do agree that that the scientific evidence was not conclusive, we submit that in interpreting the fair and equitable treatment standard in Article 2.1 of the ASNEC Investment Treaty, provisions of the Vienna Convention on the Law of Treaties needs to be considered. Article 31.3c in particular establishes that rules applicable to both parties should be considered. One of these rules is the Seoul Agreement on Climate Change, which Article 4 recognizes a precautionary principle by allowing states to take measures even in the event that the scientific evidence is not conclusive, demonstrating that in enacting this law, the Republic of Laos did not act in an unreasonable manner and hence did not violate the fair and equitable treatment standard.
Counsel, but
Counsel,
how? Yeah, please go ahead.
No, I was just saying is that, but your government has changed so fast. The contract was signed for 40 years. You didn't even wait. You changed the thing. You didn't even give them time to recover their investment in 20 years time when they were break even. So that is very unfair to them.
Mr. Arbitrator, we argue that we took into consideration the circumstances of the claimant. And we did this by giving the claimant the maximum amount of time the respondent could possibly give on the basis of the ASNIC directive. And this is evidenced on page 59 of the Statement of Uncontested Facts, paragraph 23. In any event, members of the tribunal, in the unlikely event that this tribunal finds that there has been a violation of the fair and equitable treatment standard, it is our submission that in enacting this law, the Republic of Laos was exercising its sovereign right to regulate under Article 9.1 of the ASNIC Energy Investment Treaty. Article 9, to successfully invoke Article 9.1, two conditions must be met. First, the enactment of the law must be geared to protecting plant, human, and animal life. Two, the enactment of the measure must be necessary. With respect to the first part of the test, as evidenced on page 58 of the record, paragraph 17, the Republic of Laos had experienced 6 floods within a period of 15 years, which had resulted to them losing 85,000 people and another 500,000 people left homeless, demonstrating that in enacting this law, the Republic of Laos was protecting its citizens. With respect to the second part of the test on necessity, in Continental Casualty versus Argentina, an ICSID award of 2009, it clearly, when interpreting the Argentina-USA bilateral investment treaty with a similar necessity clause, the tribunal there expressly noted that where an exception clause is an autonomous standard, the standard to be applied in interpreting it is different from customary international law. And the
So, Counsel, assuming we agree with you on this point, that you were exercising sovereign right, then what will happen to your other argument which you were arguing on attribution? At that time you were agent, now you are sovereign. So if you are sovereign and you're exercising the right and we do not agree with you, then you should be liable for that.
Mr. Arbitrator, our arguments on violation of the fair and equitable treatment standard and the invoking of Article 9.1 of the ASNIC Energy Investment Treaty is only if this tribunal finds that the enactment of the law is in fact attributable to ASNIC. If before coming to this conclusion, this tribunal finds that the enactment of this law is attributable to ASNIC, then this argument should not be considered.
Okay, so it's an alternative argument then.
Yes, Mr. Arbitrator.
Okay.
Members of the tribunal, we thus demonstrated that in enacting this law, the Republic of Laos was acting out of necessity. In conclusion, members of the tribunal, despite the fact that the Republic of Laos was experiencing the massive effects of climate change, the respondent was accommodative enough to give the investor the maximum amount of time possible to phase out coal in its territory. In addition, the Republic of Laos put in place incentive schemes for the claimant to make more profit. Hence, we submit that first, this tribunal should find that Mr. Perry Mason is partial and should be replaced. Second, that in any case, this tribunal lacks jurisdiction. In the unlikely event that this tribunal does find that it has jurisdiction, the enactment of the law on phasing out coal is attributable to ASNIC and not to the Republic of Laos. In any case, members of the tribunal, the law on phasing out coal does not violate the fair and equitable treatment standard. If there are no further questions by this tribunal, this concludes my arguments. Thank you.
Thank you, Counsel. And now we proceed to the rebuttal and surrebuttal. The claimant, if you have anything to say in response, then the floor is yours.
Thank you very much, Madam Presiding Arbitrator. Claimant just has 2 points of rebuttal. First, the respondent relied on the principle of necessity, which under international law has been stated that to rely on the principle of necessity, the state must not have contributed to the action that it is carrying out its necessary act for. Members of the tribunal, they knew about the situation in the state since 2000, even since 2000 to 2015, but went themselves to seek for investors in the coal in their coal energy generation sector. Therefore, they cannot rely on the defense of necessity. And secondly, while stating that they give Tikadia 1 the maximum time to operate, there is a difference between being given the time to operate and being given a full time to operate profitably. as seen under Article 3 of Law 72/2016, granting priority access to renewable energy generator to the national grid would affect the profitability of coal power plants, and therefore, rather than them operating to their full profitability by 2028, what would happen is that they will not be able to recoup their profits before that time. Thank you very much.
Thank you, Council. The respondent, now it is time for your rebuttal, I think.
Yes, Madam President. Council for Claimant points out to the fact that we're relying on the necessity clause under customary international law. However, this is not the case. As stated in Continental Casualty versus Argentina, an exit award of 2009, where there's an autonomous provision, where there's an autonomous exception clause, the standard to be used is not that of customary international law. And in fact, the test is to analyze whether the measure put in place plays a material or decisive contribution in the policy sought. And we have demonstrated that in enacting this law, the Republic of Laos was combating the effects of climate change. The Council for Claimant also notes the fact that we did not give them the maximum time to make profits. However, we note that first, the circumstances in the facts at hand were peculiar. The Republic of Laos experienced floods which it had no control over. In addition, on the basis of the Coal Directive, the Republic of Laos did all that it could. We further urge this tribunal to note that ASNEC is also a member state of the ASNEC Energy Investment Treaty, and the Council could have a claim against ASNEC and get the damages that they are suing for. Thank you.
Madam Chair, before they finish, I have one question to both councils.
Sure.
In the treaty, there's an amicable settlement provision. Earlier, you did not agree, but after hearing each other now for so many days, in so many rounds, do you want to consider or reconsider going back to private settlement among yourself before we decide for you? Council for Claimant, what's your position?
Yes, we do. Yes.
You want to?
Yes.
You want to go for private settlement?
I believe. Okay, we believe that the tribunal would be in the better position to make a decision.
Okay, and what about respondent?
Mr. Arbitrator, as a respondent, we submit that we have done all that we could by giving the claimant the maximum amount of time to phase out coal, by incorporating an incentive tailored for them so that they can make profits for the next 20 years. The Republic of Laos has done all that it could for the investor, and as such, we cannot go back to amicable settlement as we don't think they'll bear any fruits.
Okay, then you have to wait for our decision. Then one party will win, another party will lose. So don't cry after that then.
Thank you. So seeing that there are no further questions from my co-arbitrators, this tribunal wishes to convene and to discuss the matter. And then we will, I believe, return to the teams to announce the results unless the secretary informs us otherwise.
That is in fact correct. I will move the arbitrators to chambers. I will also move the council to a separate room if they'd like. We will also begin admitting other teams for the announcement of the awards, and I suspect that we can start doing that in about 15 minutes when the arbitrators have reached their decision. Okay?
Do we need to leave the room?
No, I'll put you in chamber. I'll put you in chambers.
Mm-hmm.
You will need to, I think, accept the request that I move you on your phone somewhere. I think you'll find that.
All right.
Yeah. And the teams, I'll also move them into a separate room so they can talk among themselves without being on the broadcast. I'm also going to pause the broadcast now.